Hello everyone, thank you for joining this event. I will begin by acknowledging the traditional custodians of the lands on which we are located and pay respect to their elders past, present and emerging. My name is Luan Ismail. I'm the founder and director of the Convergence Science Network. This webinar is being recorded and will be available for viewing again online at the conclusion of the event. I invite you to ask a question anytime during the presentation via the chat option at the right of the screen. In the past decade, our understanding of the functioning of the human brain has grown immensely. In particular, the emergence of imaging technologies has given researchers previously unimaginable knowledge and understanding about the structure and functioning of the brain. Today, we will examine an emerging area of convergence, the interplay between neuroscience and the law, or as some refer to it, neuroscience in the courtroom. What is neurolaw? Can it play an important role in defining the future of criminal justice? How is neuroscience-based evidence received by the legal profession? We hope to answer these questions in this presentation. Professor Ian Freckleton is a prominent barrister with his principal areas of practice including criminal law, administrative and human rights law, and health and medical negligence law. For 25 years, he was a lawyer, member of the Mental Health Tribunal of Victoria, including a period as acting president. He was the founding editor of Psychiatry, Psychology and Law, the Journal of the Australian and New Zealand Association of Psychiatry, Psychology and Law, and the editor of the Journal of Law and Medicine. Professor Freckleton is also a Fellow of the Academy of Social Sciences of Australia and a Fellow of the Australian Academy of Law. He has published over 700 articles and book chapters and received many honours, including being appointed an Officer of the Order of Australia in 2021 for distinguished service to law and to the legal profession across fields including health, medicine and technology. He is a Professor of Law and Professorial Fellow in Psychiatry at the University of Melbourne and an Honorary Professor of Forensic Medicine at Monash University. I would now like to invite Professor Ian Freckleton to deliver his talk, The Emergence of Neurolaw, Its Potential and Its Limitations.
Thank you very much, Luan. It's a great pleasure to be addressing the Convergence Science Network. I too commence by paying my respect to the traditional custodians of the land on which we are all meeting, and their elders past, present, and emerging. What I'm speaking to you about is an exciting and, I think, fascinating topic. I'm looking forward to reviewing a whole range of the issues which are starting to emerge in relation to the interface between neurosciences and the law. We might start now, then, Colin, by putting up the overheads, if you would. So that tells you a little bit about me. I'm a combination of, I suppose, an academic and also a practitioner, both in terms of being a Queen's Counsel in the courts and also from time to time a judge. So the next one, please. You will have seen from that first overhead that there are quite a number of books written about neurolaw. But let's get our definitions right so that we're all talking about the same thing. Neurolaw is often described as an interdisciplinary field linking the brain to law and facilitating improved understanding of human behaviour in order to assist the courts to regulate it accurately and informedly through incorporating neuroscience understanding in a whole range of areas of law, incorporating policies, procedures, and actual legal decision making. So let's go to the next one. Neuroscience will be a field of scientific endeavour well known to most of those listening to this address, the scientific study of the nervous system and its functions. And the data from neuroscience have the potential to enrich the understanding of legal decision makers and improve the quality of decision making, but only if presented in a way in which the data can be understood, assimilated, and applied. So neurolaw is fundamentally an interdisciplinary field seeking to draw upon the insights of neuroscience to enhance the quality of justice. Next one then. It has potential relevance to multiple different areas of the law. I've listed a few of them here, but that's only very much a preliminary listing of different fields of disputation that take place within the legal umbrella. For the purposes of this discussion, I'm going to concentrate on personal injury law and criminal law, because as you would understand, they immediately draw upon complex issues of foresight, capacity, and understanding on the part of an individual. And in respect of each of these, neuroscience has the potential to enrich understanding and the quality of decision making. So let's make a real start now. The next one, please. The MacArthur Foundation, a very highly resourced research body in the United States, commenced work on law and neuroscience in 2007, and in 2017 it was given a set of new tasks, heavily funded, and requested to think through what impairment of brain circuits might mean for culpability and responsibility of persons charged with criminal offences. And it was given a task of thinking through the guidance that needs to be given to the courts so that they can draw upon neuroscience evidence. And it's published the fruits of its analyses just latterly in the book, which you can see on the right-hand side of your screen. Let's go to the next one, please. Nock, now 16 years ago, talked about what he called the ultimate game. In this, he identified that a disruption of the right dorsolateral prefrontal cortex by low-frequency repetitive transcranial magnetic stimulation could substantially lower a subject's ability to reject an unfair offer in interactions between the subject and somebody else. Now, the interesting thing here was that intellectually, the subject still knew that the offers that were being made to them were unfair, but their capacity to resist taking the offers seemed to be reduced by the disruption that was engineered. This was a very interesting experiment because what it did was to show, for reasons that were not immediately apparent, but had been the subject of hypothesis, that disruption of the prefrontal cortex could impact upon persons' capacity to evaluate and make decisions that they knew were intellectually were in their best interests. It's an archetypal example of how impairment to a particular part of the brain has profound legal ramifications, at least in principle. Let's move to the next one. Robert Hare is a researcher who is a populist psychologist. His book, Without Conscience, is highly entertaining and has sold massive numbers of copies. He's also been very influential as a person researching the area of psychopathy. Now, psychopathy is high-end antisocial personality disorder. About 1% of a population satisfies the tests advanced by Hare, who's generally accepted in this area, for psychopathy. But more importantly, persons with psychopathy are 20 to 25 times more likely to be incarcerated. And there's a massive overrepresentation within the jail population of persons with psychopathy according to the Hare criteria. In the United States, it has been estimated that almost half of all violent crimes are said to be committed by psychopaths. Psychopaths often not feeling the inhibitions that the rest of us experience in terms of inflicting pain and suffering upon others. The next one, please. Going into the neuroscience of psychopathy, though, what has been postulated by Hare, whose face you can see on the top right, as an explanation for the correlation between psychopathy and criminal conduct is in part an absence of the capacity to experience empathy, perhaps caused by an impaired mirror neuron system. What we also know is that those with psychopathy have reduced volumes of grey matter in the paralimbic system. And that's the area of the brain that's responsible for emotional regulation and, I think probably crucially, self-control. So if you reduce the experience of the affect and you reduce the capacity to control behavior, you have a person who will readily respond in a gratuitously violent way and feel little remorse for having done so. Next one, please. However, it's not as straightforward as simply doing MRI scans and identifying these phenomena. Most psychopaths don't commit highly antisocial acts. Some do. Which ones? How can you predict? Can they exercise choice? Do they exercise choice? To what extent is their capacity to do so impaired? Can we tell everything from PET scans or functional MRIs? Well, it's controversial, and reasonable people differ upon this to this day. And what we can say is the research is very much ongoing, influential as Robert Hare has been for the last 30 years. His views utterly divide, psychiatrists in particular, and psychologists as well. Next one, please. DeCiti and others developed the Hare analyses by hypothesizing that psychopaths lack neural equipment for experiencing empathy. And they undertook a functional MRI on inmates in a medium security prison in the United States who were asked to view images of painful situations. And they were administered the Hare Psychopathy Checklist Revised. They exhibited different reactions when they were the subject of painful stimuli. They didn't like those. But when they saw others being exposed to painful stimuli, in essence, there was a degree of indifference amongst them. And what was found was that the ventromedial prefrontal cortex just failed really to connect or engage when psychopathic participants had to take on the perspective of others. So it was very much corroborative of this proposition that psychopaths have reduced capacity to experience empathy for others. Now, that doesn't necessarily mean that they are unaware of the consequences of their behavior and that they shouldn't do what they do. What it means is that they may not feel the emotional revulsion for the effects of their conduct that the rest of us might experience, and that therefore would deter us from engaging in highly antisocial conduct. Next one, please. So there is an area in respect of psychopathy that neuroscience has much to teach us. But still, as you can hear, there are many questions yet to be answered, more questions in some ways than there are answers elicited thus far. Let's move to another area which particularly emerges in respect of personal injury litigation. Many persons who are exposed to traumatic events experience an acute stress reaction, and a small percentage of those go on to develop post-traumatic stress disorder within the criteria enunciated by the Diagnostic and Statistical Manual of Mental Disorders of the American Psychiatric Association. We have the 5th edition from 2013 now. And so this is highly relevant to whether they should be or can be compensated if others are at fault for their having been exposed to a triggering traumatic event. So much hangs on whether a person has post-traumatic stress disorder. Post-traumatic stress disorder is not so easy to evaluate for a forensic assessor. There remains controversy about the extent to which people can embellish or even fabricate symptomatology. There are self-questionnaires that can be administered. It's a very well-known phenomenon, even within the general population. And that creates a risk, of course, that persons will at least exaggerate their symptomatology for instrumental reasons, especially in the shadow of the courts, where they may stand to receive, in potential, substantial sums by way of damages. Now, we know quite a bit about PTSD and the brain. The areas of the brain implicated by stress are the amygdala, the hippocampus, and the prefrontal cortex. And the amygdala signals a threat or a stress in the environment. The prefrontal cortex helps the amygdala to identify such events, potentially as not quite so frightening or frustrating as may at first appear. It calms things down and enables a rational response to what might otherwise be trauma-inducing and more particularly fear-inducing. Next one, please. There's been a substantial amount of neuroscientific study in this area. Preclinical and clinical studies have shown alterations in memory function after traumatic stress, as well as changes in a circuit of brain areas, which involve those three: the hippocampus, the amygdala, and the prefrontal cortex. Antidepressant medications, particularly SSRIs, such as paroxetine, have been shown to block the effects of stress and to promote a really important phenomenon, neurogenesis, and therefore recovery. Much therefore hangs off why such treatments appear to be efficacious for at least a percentage of persons with PTSD. Next, please. What one can see in the brain images before you is critical in terms of the yellow parts. There was a study which showed a failure of medial prefrontal activation in combat veterans with PTSD compared to those without it during exposure to triggers. And you can see the variability in those yellow areas. This led to multiple theories about both what causes such activation and what can be utilized to reduce it, ideally before it becomes chronic. MRI studies have shown changes in hippocampal volume in those with PTSD. Next, please. Bremner, now quite a while ago, 15 years ago, contended that stress-induced hippocampal dysfunction has the potential to mediate many of the symptoms of PTSD, which are related to memory dysregulation, including memory deficits, which are so characteristic of PTSD, as well as fragmentation of memory in abuse survivors. So there's a real relationship between the functionality of the hippocampus, symptomatology of PTSD, especially in relation to memory. Next, please. This generates a range of legal issues, as you would immediately identify. First of all, in deciding whether PTSD exists, because if we can come up with a definitive determinant of whether there is brain injury that constitutes PTSD, we have a determinative resolution of what is otherwise the fraught diagnostic question, which looks at whether the person's had the appropriate kind of exposure, whether there's re-experiencing, whether there are a variety of forms of responsiveness within the terms of the DSM-5 criteria. Now, this issue was looked at in a different context, but related, in a Court of Appeal decision in New South Wales in 2017, the Pell Air Aviation Proprietary Limited case. Now, in short, a nurse had travelled from Samoa on a plane that ended up being ditched in the sea. It was an extremely traumatic experience for the woman involved, who was there for work reasons. Unsurprisingly, she suffered from PTSD. But the question in terms of whether she was legally entitled to compensation depended upon whether she had suffered a physical injury in the form of PTSD for the purposes of the Montreal Convention relating to international carriage by air. Let's go to the next one so you can see what the Court of Appeal decided. It held that bodily injury connotes damage to a person's body. And for these purposes, damage to a person's body includes damage to a person's brain. The Court of Appeal held that if the evidence in a particular case demonstrates that there has been physical damage to a part or parts of the brain, there will have been proof of bodily injury. Then they had to descend to the case at hand. And they found that while the expert evidence justified a conclusion that the nurse's brain was malfunctioning as a result of biochemical changes, there was no evidence that her brain had physically changed. And that meant that there was not bodily injury, and so she lost her case on appeal under the criteria for under the Montreal Convention. Now you might say, well, on the basis of what we've heard already, if there was a proof from scanning that there was a change to the size of her hippocampus, that might have been definitive. But of course, you have to have before and after evaluation. And this hippocampus yardstick is not agreed upon by everybody. And this is very much a specialist area, not one into which, for the most part, psychologists would intrude. And for that matter, not one into which most psychiatrists would intrude. This is the realm of neuroscience. It's why it holds so much promise for the law and why it has the potential to be crucial in decision making in certain kinds of cases. Let's go on to the next one, please. An issue for the courts is whether children between the ages of, say, 8 and 14 should be regarded as criminally responsible. This is an issue that is subject to law reform at the moment. A key High Court decision in 2016 looked at the old doctrine of doli incapax, which is Latin for incapable of evil. And the doctrine creates a rebuttable presumption, I'll explain that in a moment, that a child between the ages of 10 and 14 cannot commit a crime because they are incapable of understanding the difference between right and wrong. Now, it's a rebuttable presumption because it's a presumption that, you worked it out, can be rebutted. And so the prosecution will generally want to ask the child questions about when they understand the difference between doing good things and bad things and consequences. And police typically ask those sorts of questions of children in an interview so as to try to get over this rebuttable presumption of incapacity. It's a very important issue when, for instance, a 13-year-old is charged with raping somebody. Do they know that it's wrong? Well, they may well. But this ancient doctrine creates a major impediment to prosecution. Now, we know that children's brains are different from adult brains. And our neuroscientific awareness of the phenomenology of difference is growing by the year. There's a Netherlands law which has been changed because of neuroscientific lobbying to extend, in effect, the doctrine of doli incapax to the early 20s because of what is said to be the profound differences between a young person's brain and an older person's. But this is very controversial because you might think most 13-year-olds know perfectly well that they cannot intrude parts of their body into parts of other people's bodies when they're saying no, and when the community says that that constitutes rape. So the capacity of neuroscience to assist with resolution of this issue, rather than our having to depend upon questions and answers about understanding of right and wrong, is an exciting development, but one which has some distance as yet to travel. Next, please. Issues arise regularly in relation to both fitness for interview and fitness to stand trial in respect of people with intellectual disabilities, fetal alcohol spectrum disorder, brain injury, psychotic illnesses, dementia, and so on. Much depends upon the particular symptomatology of an individual as to whether they are unfit to be interviewed or to stand trial. Let's go on to the next one. I'm going to tell you about a case that ended up going to the Privy Council, the highest court in the Commonwealth for many countries. It used to be for Australia, not anymore, called Pora and the Queen. Here's the background. You can see the decision ultimately was in 2015, but it related to events back in 1992, 13 years before. A woman called Burdett was raped and murdered. Pora was convicted of it 2 years later. His conviction was quashed on appeal. He was then convicted again. He appealed once more within New Zealand, which is where the case emanated from. And then finally the case went before the Privy Council in the United Kingdom. So let me tell you a little bit more about the facts. We'll go through these pretty quickly. I just want to give you a flavour of the issues. Next one, please. The key evidence against Pora was a set of admissions that he made to questions posed of him. Have a close look at his features, for those of you who know something about FASD, and you might say to yourselves that that physiognomy is certainly compatible with his having FASD. But let's focus on his admissions. Pora's cousin claimed that a week after the murder, Pora had said he discarded a blood-stained softball bat in a drain. Devastating evidence. The brother of his girlfriend said that Pora looked in a culvert where a baseball bat was visible. Baseball bat, softball bat, same sort of thing. And said it could have been the bat that wasted the deceased. So what is one to make of these things that Pora said? Next. He was interviewed in 1992, and he said he'd seen a baseball bat and a pipe, but he denied having made the admission to which I've just referred. That was attributed to him by his cousin. In 1993, he was arrested for something else, theft of a motor vehicle, and he asked if anyone had been arrested for the Burdett murder, and he said he knew who had done it. Next one. He said he'd gone to the house where Miss Burdett was, and there he said he'd seen two people, dog and hound, obviously pseudonyms, raping Miss Burdett. Next one. Then he claimed on another occasion he'd taken two men, dog and hound, to the house to carry out a burglary. At first he said he didn't know their real names, and then afterwards he said they'd returned to the car carrying a baseball bat with blood on it. Again, he was trying to exculpate himself in a kind of halting way. Next. Now, ultimately, after he'd been convicted, as you've seen a couple of times, DNA evidence showed that it was not Pora. Somebody else had raped Burdett. Now, he might have hit her with a baseball bat, but things started to get murky in light of the fact that he evidently was not the rapist. And anyway, in all of his other sexual offences, the actual offender had acted alone. So what was one to make of Pora's statements about dog and hound? and the various versions that he'd given to the police. Next one. This is where a neuropsychologist came to assist. The neuropsychologist said that Pora had fetal alcohol spectrum disorder, FASD, and that due to his brain limitations, he tended to say and do whatever he thought was to his advantage at the time. It's classic confabulation. And he had minimal insight into his own limitations, which again is typical of FASD. Next one. The evidence which went for the first time before the Privy Council about FASD said that there were real deficits in regulatory control in Pora, classic in terms of people with FASD, and that when placed in a complex situation, he was likely to act impulsively with reduced capacity to think through the consequences. He had real impairments of executive functioning and impaired reasoning capacity. Now, this means that if he was in the position of being with the offenders, he might well have behaved impulsively. Then again, if all that happened was that he was in the presence of police who were interrogating him, he might act impulsively and confabulate, saying to them what he thought they wanted to hear. Next. The neuropsychologist emphasized this risk of confabulation on the part of people with FASD, distinguished it from lying by reason of it's not really being intentional, but being a feature of impairment of the executive functions of the brain. Next, please. She found his functioning, especially in interview, to be impoverished and simple, long delays in his answering, while he seemed to be trying to work out what the assessor wanted to hear him saying. Next. Well, the Privy Council ultimately concluded quite emphatically that the evidence, particularly from the neuropsychologist, but also from a psychiatrist, established the risk that there had been a miscarriage of justice. It explained why his confessions may have been false. And that was a hypothesis consistent with innocence. The impact on that, therefore, as they put it, was difficult to overstate, and his conviction finally was overturned. Now, I just ask you rhetorically, what impact neuroscience evidence might have been able to have on a case such as this? Ultimately, and belatedly, the right result was arrived at, courtesy of neuropsychological insights into the phenomenology of FASD. But much in potential might have been contributed by neuroscientific evidence on the basis of scanning of Pora's brain. Next, please. Let me take you to another disorder which is relevant from time to time with criminal conduct. Parkinson's disease. Now, it affects huge numbers of people. 4 to 5% of people over 85, significant percentage of people over 60, 65, something in the order of 1%. Very conscious of this because a good colleague of mine became suddenly confused and dysfunctional. She never told me her age, but I think she was in her mid-60s. And sure enough, it was Parkinson's disease. The classic shaking came on late and very limited capacity to think through things. Now, we know a lot about Parkinson's disease. It's a deterioration in dopaminergic neurons in the substantia nigra pars compacta. It's characterized by accumulations of protein, Lewy bodies. It results in dementia for many people in the late phases of Parkinson's disease. And as that dementia starts to set in, it can impact upon a range of core cognitive domains, including executive dysfunction or executive functioning and the operation of memory. It can also affect or can bring about impulsiveness in behavior. And disinhibition. Next, please. Now, of course, it's far from uniform in those who suffer from it, for reasons we have no idea about, really. So much, therefore, in assessing whether it is exculpating of an offender or mitigating in terms of culpability depends upon the person's symptomatology and how one can relate the symptomatology to what happened in the context of criminal behaviour. I instance now just two criminal cases very briefly. A decision of the Court of Appeal in England in Welcome in 2009, where a sentence was substantially reduced because of the oppressive nature of prison for the offender, including difficulties of their just stopping dead at times, and real problems that they had in mobility. The point I'm making is that they had significant symptomatology of Parkinson's that was going to make their experience of prison particularly burdensome for them. Now, the right result was arrived at in terms of reducing their period of imprisonment. But as you can imagine straight away, so much depends upon the expert evidence about the impact of their Parkinsonian symptoms to assist the court to make its difficult decision at sentencing. In the Callow decision, which is a British Columbia decision from 3 years ago, a 79-year-old man was very confused at interview. He'd engaged in sexually inappropriate behaviour. And what was found was something that's really quite troubling, that his dopamine replacement therapy given for his Parkinson's symptoms had actually increased the risk of his engaging in compulsive behaviours. And the court found that this aspect, not so much the Parkinson's, but the medication given to alleviate his symptomatology, had at least constituted a partial explanation for behaviour that was quite uncharacteristic of the man himself. And again, his sentence was substantially reduced. Next, please. So from this just small cross-section of cases to which I have drawn your attention, you will have identified that neuroscience poses a series of really quite difficult challenges for the courts. Much depends upon expert neuroscientific evidence. And relating such evidence that may come from scans, PET scans, functional MRI scans, and others, to the particular litigant and to what they have done is difficult when assessing the impacts of whatever condition they have on their volition, their capacity, their cognition. So this affects issues to do with their fitness for interview, their fitness for trial, whether they are criminally responsible is a threshold matter. In other words, whether there is a complete defence. And if there isn't a complete defence, it may well mitigate their culpability and need to be reflected in a reduced sentence after an adverse finding. And finally, also, it may be relevant to how the person will cope within a custodial penal environment. But there are dangers with this kind of evidence. For neuroscience in respect of these matters is in a process of evolution. And it's difficult for the courts to draw upon it with confidence when there is so much yet to learn. As lawyers would put it, there's a risk that the evidence about neuroscience will be more prejudicial than it is probative. Next one, please. There are two provisions. Let me just make this legal for a minute. Within our evidence legislation, which is common throughout many parts of Australia and which has parallels in the United States and the United Kingdom and so on. In Victoria, just to use local provisions for a moment, which are the same as those at Commonwealth level in New South Wales and the Northern Territory in Tasmania, a court may, so it's discretionary, refuse to admit evidence if its probative value is substantially outweighed by the danger that it might be unfairly prejudicial, misleading, or confusing, or or result in undue waste of time. So it's a discretionary power to decline receipt of evidence if there is this disjunction between its value and the risks that it might pose. Now, this discretionary power exists for all cases, civil and criminal, and it's a crucial part of the architecture of evidence legislation, which determines what evidence is permitted and what is not. Go to the next one, if you would. Section 137 in the same legislation relates only to evidence adduced by the prosecution in criminal matters. And you'll see it's differently phrased. Here it's mandatory. The court must refuse to admit evidence adduced by the prosecutor if its probative value is outweighed, not substantially outweighed, just outweighed by the danger of unfair prejudice to the defendant. Now, our courts in appellate decisions at high court level have said that reliability is not the yardstick for admissibility of expert evidence or even for the operation of Section 137. But I ask you rhetorically just for a moment, where does neuroscientific evidence sit at the moment in terms of its probative value and the risk that it might pose if adduced, for instance, by the Crown against an accused person, or even if adduced by the accused person? Let's go to the next one. Stephen Morse, who's a very interesting and lively scholar, wrote an article now 16 years ago in the Ohio State Journal of Criminal Law, and he called it brain overclaim syndrome. He postulated that if it afflicts those who are inflamed by the fascinating new discoveries in the neurosciences. Now you can see what he's doing. He's sending up neuroscience a bit, but he's making a serious point as well. He said that the essential feature of this syndrome is to make claims about the implications of neuroscience for criminal responsibility that cannot be conceptually or empirically sustained. The point that he was making is that there are enthusiasts, proselytizers, who are excited by the potential for neuroscience to contribute to enhanced decision-making by the courts. But there's a risk that they will claim too much prematurely. Next one, please. A comparable phenomenon is what has been identified as the white coat effect in respect of DNA profiling. A risk that people will defer too readily to the existence of DNA evidence, or in this context, evidence from functional MRI scans. Do you remember those scans that I showed you earlier about the yellow matter? They're potent. They have the potential to influence one because one can see it. You can see the yellow, or you can see the increased volume of the hippocampus. This kind of evidence has the potential to be extremely influential. As it's been put by Senator Armstrong and colleagues, it may be over-accepted by a jury. There's a risk that there will be too much deference. Although the subtleties and the complexities, and there are plenty of them, in respect to such evidence, may be misunderstood, inadequately evaluated by lay decision makers. And when I refer to lay decision makers, I mean judges as well as jurors, because this is an area with which judges, legal practitioners, and advocates generally have little understanding. We're at the start. It's like the beginning of various forms of forensic science a few years ago. Next one, please. So let me conclude. Neurolaw is a fascinating, tantalizing area of scientific endeavor. It is a discipline in its early stages, We've had functional MRIs for some time now. We've been learning about the prefrontal cortex and the hippocampus and the amygdala for quite some while. But measuring these changes to the brain and evaluating their impact for particular individuals in particular litigation circumstances is fraught. Justice Windia in psychiatric injury litigation, now some 60 years ago, talked about the law limping behind medicine. And it does. And many of us would say that that's what should happen, that the law should not too quickly or over readily embrace new areas of expert endeavour. Because if it does so prematurely, it can reach wrong outcomes. There can be miscarriages of civil as well as of criminal justice. That case that I showed you to do with the Montreal Convention and whether changes to the brain are to be equated to bodily changes is a wonderful illustration. Because it may very well be, in fact, I think it's probably more likely than not now, that post-traumatic stress disorder does induce demonstrable changes to the brain. Perhaps talking about a bodily injury is just not the way we should be thinking. We need to become more sophisticated, but we need neuroscience to help us with that. It's starting to do so, but there is some distance to go. There is a risk that such evidence from experts, maybe enthusiasts or evangelists for neuroscience, could be inadequately construed or misconstrued by both judges and jurors. I think what we can say is that neuroscience, neuroethics, and ultimately neurolaw are an exciting area of development. They've got the potential to enhance procedures in the courts and decision-making in both civil and criminal cases. They will become a potent source of evidence enhancing decision-making in the years to come. We're not quite there yet, but it's an area that is well worth paying attention to because its potential is so significant. I hope you found some of that interesting, but let me stop there. And if there are any questions, I'd be very happy to try to answer them.
Ian, thank you very much for that very comprehensive overview of neurolaw, a fascinating and complex area which your address has identified. I'd like to ask our attendees to put a question to Professor Freckleton. We've got a bit of time. Ian, while we're waiting for some questions, can I ask, how does the judicial system, the courts, how's their response to neurolaw sort of changed? It's been a relatively new phenomenon, but sort of 10, 15 years. It's not very recent, but how has the judicial system, the judges, accepted the neuroscience-based evidence?
There have been very few attempts in this country to adduce that kind of evidence, and that's why I've referred to FASD cases and neuropsychological evidence and similar, because evidence from, for instance, functional MRIs is almost unknown in our courts as yet. There have been attempts in the United States to adduce such evidence. Largely, they've been unsuccessful. And broadly, I think what one can say is that in most courts that are familiar to us, there's been real hesitation as yet because the discipline has not developed to the point yet where forensic experts are too confident to espouse opinions which are other than generalized. And of course, the courts want specific answers in relation to particular cases. So we're in the early stages. I think if we have this conversation again in 10 years' time, it will probably be significantly different.
is there a role for broadly neuroscientists to grow the public's understanding, the court's understanding of the science? Is that done well enough?
We're just starting. There is a role in judicial education and in gatherings such as this, and gatherings of forensic psychiatrists and forensic scientists to explore these issues further. You'll recall in that very first overhead of mine, I put up representations of a range of scholarly books that have been written in the area. Most of those are in the very last few years. And some of them are arguing that we're nowhere near the point yet where such evidence could safely be adduced. Others are more confident in respect of some aspects of it. So I think what we are needing to do is to monitor where we are going, to reflect cautiously on where the areas of potential application of neuroscience lie. And little bit by little bit, when our knowledge gets to a point where it's safe, it's been peer reviewed, it's falsifiable, and there are suitable controls on it, then we can start to introduce it into our courts and enhance decision making.
Do you foresee the day when neurolaw will be almost a part of most court processes? Is it something that you tick the box, we're going to have a neurolaw element to this case? Do you see that as a possibility if the science develops, and particularly if the judicial system is more accepting of evidence? Is this a possibility?
I think so. I really do. When one looks, for instance, at the post-traumatic stress disorder area, we are on the edge of authoritative provision of data in respect of brain change and brain functioning. And that has the potential to really be game changing.
Mm.
Neuropsychology has already taken us some distance toward some of these issues, because what neuropsychologists uniquely can provide to the courts is an objective measurement of brain functioning and memory in particular, but also capacity to process information. I see in many ways neuroscience as a step along a similar trajectory, where what we will have is an authoritative, objective indicator of change and often of impairment. And it's then a matter of applying that to the circumstances of an individual. Somebody's done something on one occasion, all right, they've got impaired functionality. What does it mean? Does it mean that they're not responsible for what they did? Does it mean that there's a big change as a result of a traumatic experience or a brain injury? The role for the court remains substantial indeed, but the source of expert insight is going to change and become more of greater assistance in a whole new area. We had a transformation with DNA profiling to forensic science's capacity to assist the courts. I think we'll probably have the same with neuroscience assisting the courts, but we're not there yet.
Is there a particular reason why neurolaw is more advanced in the United States? I mean, we get the impression that, and we hear of cases where neurolaw is a factor in the presentation by the defence or the prosecution. Is there a particular reason why the US leads in this respect?
There's a lot of research in the United States. Some of the experts in neuroscience in a forensic sense are present there. There are very few indeed in Australia. The United States is also characterized by more innovation in terms of expert evidence than we have here. Although attempts have been made, largely the courts have been resistant in the United States to receiving such evidence, again, because of this disjunction between its probative value and of a risk of prejudice, and because it's hard to identify in a meaningful sense how it can contribute in a safe way to decision making by the courts. So it's a bit of a cultural phenomenon, and it's fair to say that in England, Canada, Australia, New Zealand, we're somewhat more reserved in embracing new technologies such as neuroscience.
I have a question for you from Martin Williams.
Yeah.
Can you please discuss aspects of cognitive liberty in relation to medical applications of novel drugs, particularly psychedelic medicines and their extension to personal use?
Okay. One of the many areas of research that's being undertaken at the moment is in relation to the impact of things like psilocybin, a range of psychedelic drugs uh, to assist recovery from things like post traumatic stress disorder. And there are some initial indicators that these can be therapeutically advantageous, at least for some people, very carefully handled and monitored. So the issue is again how these modalities can be introduced safely and in a way where the effects are able to be evaluated. You might remember the Timothy Leary experiments, or none of us can, but before our time, the Timothy Leary experiments in relation to LSD came out of Harvard University, but the area was taken over by enthusiasts, and scientific processes for evaluation of efficacy were singularly lacking. Now, there are some important studies that are being done in the United States and also here and Europe into those kinds of innovations at the moment. And again, it's one of those situations where probably in as few as 3 years' time, we will be talking about other options for treatment of people with a variety of conditions, including PTSD.
Thank you. We have a few minutes left, so if you have a question you'd like to submit to Professor Freckleton, please do it now. Professor, I'm not going to ask you to make predictions, but what 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 needs to happen, or what factors are important for the advancement, if you like, of neurolaw in Australia?
What we're talking about is research, careful, methodical, well conducted research, which is well underway. The bases are all there. We go to the next phase now, and then the other aspect of it is working through rigorously and ethically what the forensic ramifications are, how the courts can draw upon this extra knowledge, and that's where the neurocriminologists come in, and we need partnerships between psychiatry, psychology, neuroscience, lawyers to work these things through so that the information is provided in ways which can be utilized safely and constructively by the courts without the risk of too many errors. There, there are some really interesting questions just starting to flow too. I see this one from Alex,
Yes.
who's raising the question of someone who's had deep brain stimulation for Parkinson's. And the question is, if they have changes in their behavior and they engage in criminal conduct, who's liable? Now, it's a jolly good question, and it's a question that is starting to haunt the position, not just with deep brain stimulation, but also with the dopamine antagonists that are frequently utilized to treat Parkinson's, because we know that they can actually have an effect which is problematic in terms of people's behavior. it's a tough one, because normally the answer is that the clinician speaks to the patient and it tells them, well, these could be effects. You've got to tell us how you're going, and if anything strange is happening, let us know and we'll titrate what's going on. But with a person with significant Parkinsonian symptoms, that kind of discourse may well not be feasible. So the responsibility is going to lie heavily upon the clinician to be monitoring the situation and trying to evaluate its impact, some of which may be unintended and may not so readily have been foreseen. There is a potential for suppliers and surgeons to bear some responsibility, but I think the key aspect of it is going to be the practitioner who is monitoring the ongoing effects, because you don't just do an implant or provide a drug and leave it to the patient. You have to be watching and evaluating all the while. And that's a key component of the clinical intervention, and it's going to be fundamental in terms of liability evaluation as well.
And a final question from Andrew, Professor.
The question there is about IQ tests, and absolutely, Andrew, the IQ tests have been used as a discriminator for mental capacity. I was appearing in a case involving someone with an IQ of 42 just very recently. And it actually wasn't a criminal case, it was a civil one. And the question one asks oneself is, okay, that's in the moderate degree of intellectual disability. What does it mean? What can a person do? What do they personally understand? It's not just a numbers exercise. It depends on what skills they have and what they appreciate, and therefore when they can exercise suitable control. So the IQ number is part of it, just as the existence of a brain injury may be part of the mix, but it's only part of the answer.
Thank you, Professor. We'll need to leave it there, unfortunately. We've run a bit over time, but it's been worthwhile. Thank you again to the audience for your questions. Really appreciate that. I'd be grateful if you could take a moment to give us your feedback for the anonymous questionnaire, survey rather. There's a link on the bottom of the screen there, so please take a few minutes to tell us what you think. It's really important for us to know the value of these events and how we can continue to provide high quality events and speakers as we've had this evening. I must thank the network sponsors for their support. Their contributions make these events possible and allow us to bring people such as Professor Freckleton to inform and inspire us and let us remind us that this convergence space is a very interesting place to be. So thank you to the audience for your time this evening. Could I also thank finally Professor Freckleton? It's very rare to have someone, I think, of your convergence capacity, if I can use that term, both a leading barrister, but also having a long-term interest in these health issues and bringing your expertise in law to bear on this issue, which is going to be increasingly popular, if I can use that term, something that we'll hear more about. It may not be called neurolaw, but those of us who have heard you this evening will understand exactly what it is. I'm sure many of the people who have heard your address this evening will continue to take an interest in this field. The Convergent Science Network certainly will. And again, thank you very much for a very informative and thought-provoking presentation. So thank you, Professor Freckleton. Please remain safe and healthy. We'll see you next time. Goodbye.